Good morning, Mr. Obligato.
If the court please, my name is Carlo Obligato, and I appear as appellate counsel for Mr. Edge. Seated with me today is attorney Brian Kelly, who is trial counsel for Mr. Edge and who brought the successful 211-3 petition that resulted in this case being reserved and reported to the full bench. Unlike the first case before the court this morning that had a multiplicity of issues, this has one single issue. In Brown v. Ohio, the United States Supreme Court held that a state may not prosecute a defendant a second time for an offense which comprehends a lesser included offense of which the defendant has already been convicted.
What is the effect on this case of the holding in the Mass Appeals Court case in Johnson? I think it's 45 Mass Appeals 473, a 1998 case. Are you familiar with that case?
I think I cited in my brief, Your
Yes.
Honor.
It's the case that says it involved threats and a protective order.
Well, Your Honor, I think in that case, I think I distinguished that case in my brief. I think it may be cited by the lower court. Threats, of course, are not have completely different elements than does the stalking indictment. The issue before this court is whether or not a Chapter 209A violation is a lesser included offense of subsection B of Chapter 265, Section 43B. Section 43A is the stalking statute.
Right.
Section 43B is the aggravated offense. That is stalking in violation of a court order. One of the enumerated orders in subsection B is, in fact, Chapter 209A. So by definition, we think it's a simple equation. You've got Section 43A, stalking, Section 43B, stalking in violation of a court order, that court order being, namely, Chapter 209A.
Mr. Obligato, do I understand this correctly, that if before the grand jury the evidence presented of Mr. Edge's violation of the April 209A order
Correct.
had been everything minus the three that were the subject of the conviction, that would be okay?
Would the indictment be okay?
Yeah.
Well, that gets me almost to the conclusion of my argument in the Commonwealth's prayer for relief. You don't know if...
No, I understand. No, I understand your argument about you don't know what the grand jury would have done. I'm just sort of, as a theoretical matter, let's just say they started from that proposition.
They started with everything but for that to which he pled guilty?
Yeah, I'm really just
Then
trying
you
to get
don't know whether or not, with that being out of the picture...
No, all I'm trying to do, and I'm not being very clear, I apologize. I'm just trying to figure out, it's not the fact that he was convicted of the 209A that's the problem from your perspective. The problem is that the basis of that conviction, the acts that went to make up that conviction, were presented as part of the stalking evidence to the grand jury.
Precisely, as the predicate acts.
Well, it's three of several.
Well, three of several.
Yes.
Precisely.
Right.
And so, therefore, that is the lesser offense, and the holding in Brown as articulated by this court in Commonwealth versus Norman makes it absolutely clear that if it's a lesser offense, it doesn't have to be the greater offense, it can be the lesser offense, as Brown was. In Brown versus Ohio, the defendant pled guilty to, as I recall, joyriding, and then they wanted to try him for the greater offense of auto theft. The plea precluded that from occurring.
Could you tell me why this isn't Commonwealth versus Alphas? What's the difference?
the difference in Alphas, and the Commonwealth appears to be relying on the dictum in Alphas, dealing with the notice for a 43C violation. The difference in Alphas is that, first off, Alphas was contesting his conviction. Here, as I set forth in our reply brief, the distinction, first off, is that Edge pled guilty to the 209A violations. In Alphas, he was disputing whether or not he had violated one of the alternative enumerated orders set forth in subsection B of the statute. But the Commonwealth hooks on to some dictum in a footnote in Your Honor's decision in that case. And Your Honor refers in that case to what are extra statutory protections. And the Commonwealth misconstrues extra statutory as being instead a separate statutory element that somehow or other the defendant has to establish under a 209A violation that it would not have to establish.
I mean the Commonwealth.
The Commonwealth.
Yeah.
Under 43B, so that therefore there is not a commonality of elements. But that is not an element. This Court made it very clear in the Delaney decision that improper service or even failure to service does not render a prosecution under a protective order violation improper. It may go to the relevance as to whether or not the defendant had knowledge, but that's all we're talking about, is did the defendant know that there was an outstanding 209A order or some other order of that genre.
What do you say? The Commonwealth argues that the elements are different here under the Morey test.
I struggle to find where they are not. The elements of 209A are wholly subsumed within 43B. You cannot have a conviction under subsection 43B if you have not satisfied all of the elements of Chapter 209A. It's simply impossible. So by definition, the one is the lesser included of the other offense.
Now you cite, I mean, you cite Commonwealth versus Mills, which was a case in which the court, just sort of in talking about what happened below, says the defendant was convicted of the lesser included offense of violating the restraining order.
Precisely. I mean, it's the closest we come, but that's, I mean,
I know, it wasn't discussed.
It wasn't discussed. It was like at the very beginning of the decision it says, on the stalking charge, the defendant was found guilty of the lesser included offense of violation of an abuse prevention order. That's not, I'm not going to rely here
My
today.
only question there is it clear that would have had to have been a 43B conviction? Because it just mentions 43.
It's just, precisely. As many of these cases do that I discussed in my brief, they're not distinguishing, and they need not, in the particular circumstances of the case, distinguish between what is 43A versus B or 43 in general.
Can I ask you this? The closest parallel that comes to my mind is the RICO statute, where you have a pattern of racketeering, which might include several murders, a couple of other things, and perhaps there have already been convictions for those murders. Have you seen anything parallel? Has this come up in the RICO context where the claim is, look, I've already been convicted of some of the underlying predicate acts. You can't then use them as predicate acts in a RICO indictment.
I think that, you're testing my memory, but I think perhaps in the U.S. Supreme Court case, the Rutledge case, that dealt with whether or not they could, it was not a RICO case, but it dealt with whether or not they could prosecute the defendant for a criminal conspiracy enterprise, which I think is tantamount to RICO, when he'd already been convicted of a conspiracy. Of course, you can charge and try somebody for conspiracy in a substantive offense, but I think in Rutledge they felt that the two were too close.
So I think, so if the legislature, to do what the legislature wants to do, I take it, according to you, they would have to have something like a second and subsequent sentencing scheme, or a scheme for a habitual criminal, something like that.
That's right.
That's
But-
what they would need. They can't do it this way.
Right, but this is not a recidivist statute.
I
This is not an enhancer in that respect.
Yeah, yeah.
So,
Yeah.
so,
Not the legislature here.
Well,
I
I'm
mean,
saying what makes the statute wrong.
right, but I mean, I guess I'm just saying that the district attorney could have, in this case, since there seem to have been a lot of acts that were available, alleged acts, that the district attorney could have gone to the grand jury and just avoided these three, right? And I think you would say that's fine.
that's correct, and then see where the chips fall, whether or not they still get the stalking indictment. But that is if they want to get a stalking indictment under subsection A. But on the other hand, if you want to get it under subsection B, you have to, as an element, show that there was a court order in effect.
Yeah.
If you show that, then you have to tell the grand jury, and this is a separate issue that we've not brought to the court, that, oh, by the way, he's already pled guilty to this 209A violation or these 209A violations, because otherwise you put yourself into this predicament that, well, okay, you're trying to adjudicate him a second time for something to which he's pled
No,
guilty.
couldn't you just tell the grand jury that there is an outstanding court order?
No, you have to tell him he's already pled guilty to it.
Okay. All right. Could I ask-
Otherwise, you deal with a McCarthy violation.
Right. Could you address, please, what you said that you would in the beginning about the Commonwealth's request for relief?
Well, the Commonwealth requests for relief that, in the alternative to our request, that this court simply dismiss the indictment, that instead the court allow it to try the defendant absent the, as they say, 16 actions on which the defendant has already been convicted.
In other words, what Justice Spotswood was
Precisely.
suggesting should have been done before the grand jury.
And our response to that is that, no, that is not a viable argument, because this erroneously presumes that the grand jury would have handed down an indictment for stalking under subsection B, notwithstanding the absence of their 16 actions. And you don't know that.
Mr. Abogado, in response to Justice Cowan's question, you said you'd have to put before the grand jury that there was a conviction of the 209A order. Why would you? All it says is whoever commits the crime of stalking in violation of a temporary restraining order.
I misspoke. I mean, if in reality he did plead guilty, but if this is before the plea, then yes, you have to put before the court there is a court order
But you
in
don't
effect.
need, all I'm saying is you don't need to have had the conviction in order to be
I
within
agree.
this statute.
I agree.
Okay,
But you do need to have the court order.
correct.
I'd point out that the lower court, in its analysis, as its fundamental flaw, treats 43A and 43B as fungible. And I'll just indulge the court, if I may. If you look at the lower court's discussion, which is at Record Appendix 106 on my brief, it sets out the elements of 43A, but it cites 43B. So citing the elements of 43A, instead he cites 43B, he leaves out the critical element, namely the violation of a court order. And then on page 109, which is basically the essence of his analysis, he says a conviction under 209A requires a court order exists and that the defendant have knowledge of the order. Okay. But then he says a conviction for stalking requires proof of at least 3 incidents of conduct by the defendant which would cause an ordinary person substantial emotional distress. That's stalking under 43A. He leaves out, but it also requires violation of a court order. And
Mr.
that's the
Obbligato, just on that same page, I take it that that's essentially, your argument would essentially address the Superior Court judge's reliance on Martinez, the notion that you've got all of this stuff in the same, you can have stalking and 209A orders based on the same pattern of conduct, just doesn't address the 43B problem.
That's correct. And we concede the Commonwealth could try somebody for 209A, the Delaney case establishes that fact. You can try somebody for 209A violations simultaneous with violations of the stalking statute. But if as the basis for the stalking under a 43B prosecution, if the basis for it is the 209A violations, then you're facing a predicament of duplicative convictions.
Thank you, Mr.
Can I
Obligati.
just ask
Sure.
one question? So if the Commonwealth were to have proceeded, maybe I misunderstand what I just heard. If the Commonwealth were to proceed just under 43A, stalking, right, it could have used the evidence that was the foundation of the prior convictions for 209A violations?
No.
Because it wouldn't be stalking in violation
I
of the
understand that's correct.
So
No,
it could
I
If-
thought what you're arguing is that the Commonwealth could proceed by using evidence of violations that were not
No, I'm,
the subject of the
The
other-
guilty plea.
of the
Right.
guilty plea.
Right.
Right.
well,
Was that not the
no.
question?
If the Commonwealth had proceeded under 43A, which is just the stalking statute, not stalking in violation of a court order, but the incidents that it described in the stalking statute included incidents that also formed the basis of a prior violation of a 209A order, would that have been okay?
And this assumes that he hadn't pled guilty to them?
No, that he's pled guilty to the 209A.
Okay, if he's pled guilty to them, then I think you come up against
Same thing.
Justice
That's
Cowan's
this case.
decision in the Cabrera case, 449 Mass. 825, where you'd have to look to see whether or not the defendant was being punished for violating both statutes, unless it can be said with certainty that his actions were so closely related, in fact, as to constitute substance but a single crime. So you'd still be dealing with duplicative convictions.
Okay, thank you.
Thank you.
Thank you, Mr. Obligati. Ms. Cahill? Ms. Cahill, could I just ask you a preliminary question? I'm sure you've read the reply brief, right?
Excuse me?
You have read the reply brief?
I have,
and
Your Honor.
Footnote 1, the defendant asserts that the argument that you're positing here was not one presented in any of its prior submissions. Is that correct?
Excuse me, I'm sorry, I'm just having trouble hearing you.
I don't know if, is my microphone?
It's my ears.
I'm sorry. The defendant, in footnote 1 of
Yes.
its reply brief, makes the claim that the argument that the Commonwealth is making here was not presented in any of its prior submissions, and I just wanted to know whether or not you agree with that.
I do not agree with that, Your
Okay.
Honor. The Commonwealth, since day one, since argument in front of Judge Locke in Brockton Superior Court, argued that violation or restraining order is not a lesser included, that violation or
Not a
restraining
lesser
order.
included of 43A or
43B. And in my argument, and actually in my brief to the Superior Court Justice and under the 211.3, I continue to argue that violation or restraining order is not a lesser included offense of 43B. It is correct the first time I cited Commonwealth versus Alphas is in my brief to
Right.
this court, but my argument has been from day one that it is not a lesser included, that stalking is a pattern of behavior in which somebody has to act at least 3 separate times of behavior directed towards someone to harass them, plus make a threat. And a single act of violation or restraining order is not a lesser included offense of that violation. In the simplest of terms, I think you can decide this case very simply today.
How do
And
you
that
d-
is by
wha- wha-
following.
What is the court order that is being? What is in violation of a court order? What is the court order?
The court order in this case is a
Correct.
209A, but 43B enumerates different statutes and different court orders that come under 43B, and the court can look at to see if one of these specific orders was in effect.
I understand. Is in this case, though, as I understand it, and I may be wrong, at least on several occasions, the behavior that was part of the court order on which the Commonwealth is relying is the same behavior that's at issue here. Am I correct?
some of the behavior,
Yes, but
Is-
some, but it's in, you may have a Venn diagram, so it's not all of it, but some of it, correct?
some of it, correct,
Which
Your
is
Honor.
why you're now saying, just take that, just eliminate that and affirm the motion to dismiss, correct?
I am saying, Your Honor, that if I understand your question properly, is that the Commonwealth has the victim in this case got a restraining order under Chapter 209A, Section 3, prohibited the defendant from contacting her, from coming to her home,
Correct,
from coming from her
yes.
place. And from April 19th of 2006 until July 27th of 2006, the defendant committed 43 separate acts of harassment towards her, and each one of those acts were in violation of that court order because they were contacts to her. Multiple acts, I believe it's 14 of those 42, actually was a specific threat to her when he called her workplace at D'Angelo's and said, "I'm going to slit your throat." And co-workers answered, "And tell my wife I'm going to slit her throat because she's sleeping with somebody else." So I suggest, my argument is that each one of those 43 acts that the Commonwealth presented to the grand jury is actually a violation of that court order.
Right.
Yes?
But included to what you presented to the grand jury were the acts that were the basis of the conviction for violating that court order.
That's correct, and those are four of the 43 acts.
What the grand jury heard.
They did not hear the defendant was charged. They did not hear the
It doesn't
defendant was
make
convicted.
any difference.
They heard, but the Commonwealth has the statute says the Commonwealth has to prove a pattern of behavior. Those
Did you,
specific
let me
acts
ask,
were part of that pattern.
let me ask you this. Did the Commonwealth have sufficient evidence of a pattern of behavior leaving those aside?
I believe that the Commonwealth did, Your Honor. But the Commonwealth should not be limited into only using what is not convictions. If you look at Commonwealth v. White,
Let's assume that you've got 3 acts by a defendant on the basis of which the Commonwealth obtains a 209A order. Okay? So you've got the defendant does 3 things. And, not the Commonwealth,
The victim.
the victim obtains a 209A order.
after those 3 acts or before?
No, the 3 things give rise to a 209A order. So he does them in January, February, March, and the victim obtains an order in April. And then in May, he does something that violates the order, correct?
Correct.
He can be held in contempt. He can do all kinds of things, correct?
You can be charged with violation of the restraining order, correct?
Is it the Commonwealth's position that he has violated 43B at that point?
He has only violated potentially 43A because after the restraining order was issued, there was only one act, and that's the May Act. So the Commonwealth could not proceed on a 43B charge because his acts were not at least 3 acts were not in violation. But the Commonwealth would go
But
forward on a 43A.
as soon as you have 3 acts, why do you need, as soon as you have 4, 5, and 6, why do you need 1, 2, and 3?
You could
I-
use 1, 2, and 3.
Well, they did. That's the problem.
We could use 1, 2, and 3 because we can use
That-
everything that's included in his pattern of behavior.
Okay.
And if you look at Commonwealth v. White,
But he has
in
alre-
White, the court allowed prior convictions for, I believe it was 2 or 3 acts of violence, which were assault and batteries and threats, as the predicate for the stalking. And the court allowed the prior convictions to be used as elements that created the pattern of stalking in White.
Well, let me ask it this way. You've got a restraining order. The defendant violates it on 3 occasions. He's charged and convicted. He does 3 things after the restraining order. He's charged and convicted with violating a restraining order. So there are 3 convictions for violation of restraining order, 3 acts. You then bring a stalking complaint under 43B. based on those 3 violations for which he's been convicted. Okay?
Okay.
Is that all right?
I would suggest, Your Honor, that that is a separate argument to double jeopardy, not that violation of restraining order is a lesser included offense, but compare it to the argument in Rutledge that now the defendant has pleaded guilty to these 3 violations. Nothing new has happened, but the Commonwealth's going to charge him under 43B, and that would almost go towards the double jeopardy harassment by prosecution.
Or that's a
Prosecution
Cabrera-
harassment.
Cabrera analysis, duplicate punishments for, in essence, the same conduct?
Why is this different? Why is this case different?
The case is different
This case.
because in Alphas, the court stated
But
that
with all due respect, Ms. Cahill, that footnote about, which I have here, the extra
Extra statutory
extra
protections.
protections doesn't go to this issue.
But, Your Honor, if you look at it, and it's not the extra statutory protections, the court goes on to state that violation of Section 34C is a separate offense from one under 43B, and that 34C is not a prerequisite to prosecution under the stalking statute. I don't have insight to why the court made that decision, but that was the decision in Alphas. And I suggest if I stood here before you today with 42 acts in a 4-month period, and 4 of them were convictions for violations under 34C instead of 209A, I wouldn't be standing here based on the court's notation.
It's possible, but
In
it is
Ireland.
it is also possible that nobody raised the question. So I don't know, I mean, Alphas, this issue was not presented.
But 34C is the probate court equivalent of 209A Section 7. So in saying 34C is not a prerequisite, the court also said that 209A Chapter 7 is not a prerequisite, and that a violation of 209A Chapter 7 is what we have today, is a separate offense from one under 43B. And the court is saying it's not a lesser included, it is a separate offense.
What do you say to the language in the, I'll find it, the case that says it is a lesser included? I mean, just in passing.
That's Mills, Your Honor.
Mills.
And the only thing I can say to that is actually what the court said before, is that it was in the first sentence of the decision. It was an exploitation or mere recitation of procedural background, and there was no factual information of a restraining order, of the stalking charge. Was the stalking in violation of restraining order? Was it 43A, 43B? So, unfortunately, we can't rely on Commonwealth v. Mills because it was more of just a procedural recitation of the background information. If I may, the test is the same elements test. Is a violation of restraining order a lesser included offense? And we look at the same elements test. Violation of restraining order, you have to prove there was a restraining order in effect, that the defendant had knowledge of that, and that that restraining order was violated. In the stalking statute, you have to prove the 4 or 5 elements that were over a period of time. There was a pattern of acts. They caused the victim to be seriously harmed. The acts were willfully done. The defendant made a threat. There is no case on point on this, and I looked to the model jury instructions, the instructions that have been given in past courts, including instructions given in Alphas, as to 43B. And the only thing I could find was note 1 that says 43B establishes an aggravated offense.
Under 43B, if you had a 43B complaint that was relying on an incident of a 209A violation that was also charged, but no plea and no conviction, but was charged in that case, in the same case, could the jury come back with a not guilty on the 43B and well, they could come back, I guess, on
I suggest they could come back with a not guilty on the violation of restraining order and a guilty on the 43B, because the Commonwealth has to prove in a violation order, service or notice, and that it was violated. In the jury instructions for 43B, the Commonwealth first has to prove stalking. And then once we get to stalking, then the jury is directed to look, was there an order, and did these acts that you found created a pattern of stalking violate the court order? And how the jury does that is the Commonwealth gives them the restraining order, and they look, were these boxes checked?
Are
Was that
you
contact?
suggesting that the elements in stalking are different because, one, you have to establish a pattern, and two, you have to establish that the defendant made a threat?
Different from which, Your Honor?
From the
violation
violation
of
of a
restraining
restraining
order?
order.
Yes, Your Honor.
But don't you
And-
have to prove that there was a violation of the restraining order, if that's one of the underlying incidents?
No, not that there was a violation, Your Honor, that the conduct that created the pattern is in direct violation to one of the boxes checked and enumerated on the restraining order.
Ms. Cahill, maybe I'm just missing something, and because it's complicated, but the whole point of Brown against Ohio and in Nielsen, which Brown quoted and so on, was to look at incidents, to look at conduct, to look at what somebody had done. Isn't that what's at issue here? So why are you insistent on looking at elements? I know it's because of a lesser included offense, but
Correct, Your Honor. And stalking is a pattern of behavior. And 43B is an enhancement of the crime. The crime is stalking. That is the crime, whether somebody stalked somebody or didn't stalk somebody. And that's the plain language. And the rest of 43, which is 43B, is an enhancement. The legislator said, stalking somebody, we're going to create a law that when you stalk somebody, you are going to be punished. And what we see is that if there's an open restraining order, we're going to enhance that, because if you're stalking somebody when a court has issued an order, we're going to enhance that penalty. I guess Justice Cordy spoke of RICO. The thing I can find most akin and alike to it is a school zone violation. The legislature created a protective zone
school zone violation is completely different. It doesn't go to the same incidents, it doesn't go to the same conduct, it doesn't go to anything.
you have to prove that there was possession with intent to distribute drugs. And then if you prove that, like if the Commonwealth proves stalking, then we look to the enhancement. Was it
That's a
done?
sentencing enhancement. That's what I asked about before. If a sentencing enhancement, if we had a statute before us that provided a sentencing enhancement, that would be an entirely different story.
And I suggest, Your Honor, that the legislature's intent in this case was to stop domestic violence. We can't decide, you know what, this defendant...
Cahill, of course it was to stop that, and of course if people who violate, the legislature is perfectly free to establish another crime that in fact results in a greater sentence. But I have your last paragraph of your brief that says, it'll be fine, just tell us that we can't introduce evidence of the underlying incidents. I mean, you're saying there's a problem here.
I'm not saying that, Your Honor. What I'm saying is I think under ALPHIS, the Commonwealth can use these prior
Did
convictions.
the grand jury have that information?
That there were convictions? No.
No. Where's your-
That they had the acts of the three letters, one to Satan, one to the two cats, and the phone calls from the Brockton police. But they did not have information that there was an arrest made or there were convictions.
Okay. Thank you, Ms. Cahill.